Good morning, everyone, and welcome to the next instalment in the IR35 Navigator Think Tank series. Today, we're going to be talking on that rare thing, Hmrc leniency. And I'm joined by our expert panel, as usual, to talk around what Hmrc has offered as 12 months leniency around the IR35 reforms. Perhaps somewhat misleading, we're going to dive into what leniency actually means. We'll also be talking about how agencies, end hirers, and contractors can be preparing or making necessary changes given the IR35 reforms are now with us. So I'm joined today by our panel, who will be taking it in turns to talk through different points. But first, let's have a look at leniency. Tom, let me come to you. Leniency with Hmrc, as I say, isn't the most common thing. But what does leniency look like to you in this way?
We've got to be careful when we say the word leniency, because leniency kind of suggests that for the first 12 months, you know, we expect that you won't have got your act together, and therefore we'll take a very light touch. And it doesn't quite mean that. What it means is the rules are in place. 6th of April 2021, IR35 in the public sector is live. You have responsibilities. You need to meet those responsibilities. You need to do status determinations. You need to have a process for dispute in place. You need to make deductions if you are liable to make deductions inside IR35. What Hmrc is saying is that if you have taken reasonable care over all of those steps, then they will be lenient on the penalty if you got something wrong. So they're not saying that we will forgive the tax that should have been paid by you, we'll forgive that you haven't met your obligations. We simply will say that if you have taken some degree of care and got it wrong, we won't charge you a penalty. But as we've said in previous podcasts, the tax alone is enough to put a business under. So it's not something that I would rely on as a business to say, well, I've got 12 months to get this right. You don't. You've had 2 years to get this right. It's now here, and you have to be very aware of what your obligations are.
So what do those penalties look like then? Let's kind of delve into those a bit. Obviously, we talked around the tax, and we'll come on to the tax liability. But what are the penalties that Hmrc are going to be foregoing, and when might they not apply, or when might the leniency not apply?
So for many years now, we've had this kind of penalty tariff for inaccurate documents, and a document can be anything from a claim form to a tax return. So what they're saying here is if you submit documents, monthly pay-as-you-earn submissions is a document, and that is inaccurate, you are liable to a penalty. Now, that penalty is based on behaviours. There's 4 types of behaviours. There's a mistake despite taking reasonable care. There's carelessness, there's deliberate, and there's deliberate and concealed. Now, none of those have statutory definitions, so don't go looking in the legislation for what they mean. You will find case law, and Hmrc guidance is what will give you a guide as to what falls into those behaviours. Now, what Hmrc have said is that if you fall into a careless or a mistake despite taking reasonable care category, then they won't charge a penalty. Normally, those penalties would range between 0 and 30%, depending on prompted, unprompted, telling, helping, giving, all sorts of abatements that can be had for that. But if you fall into the deliberate category, then they will charge a penalty, because that clearly shows you've not done something you should have done. And one of the definitions or one of the descriptions of deliberate in the Hmrc manual is deliberately failing to take action known to be necessary to ensure a return or document is accurate. And that would be what Hmrc would be looking at, whether you have just absolutely just willfully neglected your obligations. And it's not just the penalty you need to be concerned about. There's other consequences of that. If you have been served with a deliberate penalty, you fall into the Managing Deliberate Defaulters Programme. Now, what that means for the next 2 to 5 years, Hmrc are going to very heavily scrutinise you. You can expect unannounced visits to look at your business records and make sure you've got your processes in place. You can expect extra scrutiny of all of your documents that are being submitted, and that can be anything from VAT returns, pay-as-you-earn returns, corporation tax returns. So there's added consequences. You can go further than that. HMRC have got their deliberate defaulters list that they publish. So if you have been served with a deliberate penalty and the tax at stake was over £25,000, your name will be published quarterly on HMRC's website, and that will stay there for 12 months. Now, reputationally, that is disastrous. It's catastrophic. So there's lots to get your teeth into here, but the bottom line is that, you know, people do make mistakes. That's fine. HMRC will accept that. But if you just willfully say that, you know, I think I've got a green light for 12 months to not really bother about this, you're going to end up in a lot of hot water.
So what kind of decisions would you say? We spoke last week on the session around the reasonable care requirement, and we've actually had a lot of discussions with this with people post that on what the reasonable care requirement truly means. Layla, I know you have kind of posed the question on LinkedIn over the course of the week around what happens when an agency doesn't bring in the notion of reasonable care, but makes a determination as inside IR35, what the practical results of that. HMRC aren't necessarily going to get involved because all of the tax is being conducted. So what's there to lose? So when we're looking at the ideas of reasonable care or genuine mistake, what are going to be examples of that don't meet that criteria, that probably are going to fall outside of HMRC's leniency side of things? Tom, Layla, I wonder whether either of you have any thoughts on that.
I think what I'd probably say is let's look first at what your responsibilities are. So you have a responsibility to make an accurate employment status determination, an SDS, as we know it, and that should reflect the actual working practices of the contractor, and it should obviously have reasonable care taken in coming to that conclusion. You then have to have developed a client-led status disagreement process for disputing that SDS. If the contractor disagrees with the conclusion that's been drawn, then there has to be a process in place that allows them to make representations and have discussions around why they believe it should be outside IR35 rather than inside. You need to pass all of that to the relevant parties. So you need to pass that SDS up the chain to the agencies and any other party that's there. Lastly, you obviously need to operate pay-as-you-earn on the payments if it's deemed inside IR35. So those are what HMRC expects you to do as a business and is your responsibility of a business. Clearly, not doing any of those things will be deliberate because it's your obligation. If you do a couple of those things with the right intentions, or perhaps you get your SDS wrong because you've had a misunderstanding of the rules, but you can actually genuinely show that you have taken reasonable care and you've done your best to understand the process and you've done your best to understand the determination, that's where you may get some leniency. But as we've already said, it's very different from saying you don't owe the tax.
Yeah, so when we do look at reasonable care, HMRC have published and kind of said what they believe that means, and it means that a client or anyone in the chain should act in a way that would be expected of a prudent and reasonable person in that client's position. So if you're an end client, and I think the important thing is having the knowledge of payroll and how it works and making a correct assessment, it's not that everyone's going to have that knowledge. It's quite complicated. It could be seen as complicated. So what do you do then? I mean, I know HMRC, they've made arrangements. They've had a lot of webinars. They've posted a lot about payroll and tried to educate people. But what is actually taking reasonable care in understanding the rules and actually doing what you need to do and making those correct assessments? So it's not, you can't, as well, in HMRC's guidance, you can't just subcontract the assessment to someone else and just be like, okay, that's fine, someone's going to deal with it. You need to be involved in that process and understand what your requirements are. And that's what reasonable care is getting that knowledge, engaging with someone to help you if needed, and just making sure that anyone who is making that assessment has the correct tools to do so.
I think the overriding message there is that the reasonable care points that we discussed in last week's think tank should be the kind of central focus of making sure you're doing things right. And if you're falling outside of that reasonable care requirements, then whether it's by mistake or whether it's deliberate is really going to decide HMRC's leniency against you moving forward. Okay, interesting points. Would anyone else like to add anything to those points around leniency? Bernie, I think you've got your hand up.
Yeah, I think I just wanted to kind of, I guess, just clarify a little bit, you know, with clients when they're making the status determinations, you know, they are required to take reasonable care. But if there are any agencies in the chain who are told by a client that a contractor is inside IR35 and they are therefore required to make the deductions, that is not about reasonable care. That is an absolute obligation to make the correct deductions for tax and NICs. So for any agencies in the chain, there is no reasonable care. You've got to do it, and you've got to get it right. You know, and as Tom said, if they don't quite get it right, you know, they deduct tax and NICs, but for some reason it's not quite done right, well then, you know, potentially in the first 12 months, those additional penalties won't be due. But, you know, it is only the client that has the benefit of that kind of variable obligation of reasonable care. Everyone else in the chain has an absolute obligation.
Yeah, absolutely. Good point of clarification there. In terms of the practicalities of the situation, we've seen a lot of companies, agencies in particular, looking to mitigate any losses or be able to recoup any losses for an inaccurate IR35 assessment, typically through the contract provisions in from a contractor from the PSC. Carla, I know you've looked at some of the more kind of aggressive, I guess, indemnity clauses that sit within the contracts. Do you have any thoughts on what agencies and clients or contractors need to be looking out for in the contracts when it comes to those kind of things and this notion of leniency or trying to recoup IR35, recoup liabilities further down the chain where the fee payer is held to be liable for an inaccurate assessment?
Yeah, absolutely. Obviously, everybody should be looking at their contract anyway, but even more so now that it's very likely there will be onerous tax indemnities in your contract. So whilst the liability may sit with somebody else in the chain with respect to statutory liability, there's nothing to stop them from contractually passing that liability down the chain. So it is very prudent to read your contract, not just look in the indemnities or liabilities section, but to read the entire contract, because it could be stuck into some other boilerplate clause in small print, and make sure you're aware what you're signing up to, and make sure that obviously that you've got adequate insurance that will cover any losses in that respect.
Great. Okay. Chris, is there anything you want to add to the leniency points before we go into, as a result, how can people start planning?
No, I think that's been pretty well covered. Thank you.
Okay, good. All right. So with regard on the basis of observing, therefore, that leniency is only focused around penalties, is not focused around the tax loss. And as Tom said earlier, a tax loss identified has the potential, or certainly a few, has the potential to put businesses into incredibly precarious positions just when they're getting out of, particularly agencies, just when they're getting out of a rough year. So how can companies, entities in the chain start planning? Clearly, we would hope that most of the planning has happened already over the last 2 years, and it's certainly the case that for those we work with, effective plans are in place, effective testing regimes are in place, and effective compliance frameworks are in place. But what should those who are just starting to implement IR35 into their businesses look at first? we're going to go with each stage in the compliance chain. So end clients first of all. Bernie, I wonder if I can come to you with what your kind of key pointers are for end clients in preparing their compliance frameworks.
Well, I mean, obviously, first of all, clients need to be very clear about how all of their contractors are engaged. You know, that's the first starting point, because obviously not every single contractor needs to have an IR35 status determination done. It's only if that contractor operates via a PSC. And certainly, you know, both in the run up to the public sector go live and the private sector go live, you know, end clients didn't really know how many contractors they engaged, whether that's directly or via an agency. And they certainly didn't know how they were supplying their services. You know, they didn't know if they were a PAYE temp, they didn't know if they were umbrella, they didn't know if they were a PSC. So knowing that is your starting point, and then that gives you, if you like, your population for the purposes of needing to do, you know, the SDS. And, you know, as Layla, you know, made very clear, it's doing a status determination is a really niche area of law. It is complicated. There is no kind of easy checklist that the government issues where you just tick a few boxes, and if you get 3 out of 5, then, you know, you're outside. You know, it's based on 20 years of case law. So either ensuring you have the resources in-house, you know, whether that exists already or are bought in, or using a good external partner to support you in doing that is really important. Because, you know, as we said, clients have to take reasonable care. And the larger the client and the larger the number of contractors they have, the higher that threshold will be in terms of whether they have discharged that burden of reasonable care. So, you know, they need to make sure that they've done all of that and they're doing it. But it's not just about initially. And I think that's the thing. A lot of clients have managed to just get themselves over the line for the current population for April. But now they've got to think about, what does that mean longer term? You know, making sure assignments are reassessed on a relatively regular basis to make sure that nothing has changed. We know that, you know, over time, you know, the nature of assignments can change, but also for any new roles, you know, perhaps that they didn't assess previously, but will need to be assessed. So it's an infrastructure that needs to be implemented, not just a couple of processes to get you over the line. You know, it's got to be from the ground up. And I think actually the BAU aspect of the off-payroll rules, which is kind of where we are now, is in some ways that's harder than just doing the initial status determinations and putting in place a little quick process for any disagreements. You know, now they've got to make it work as business as usual, and every role has to be released, you know, well, not released, but has to have a status determination statement done. And the earlier in the process they can do it, the more they know whether a particular contractor engagement model is suitable for that role, etc. So that's really the hard thing.
Absolutely. Now, I think I saw a figure earlier today or yesterday that 1.2 million CEST determinations have been given. So clearly people are looking to rely on that tool. We've covered in a number of different sessions why CEST might not be the right way to go. So we won't labour that point, but I mean, do you have any thoughts on that? Do you think people are relying on CEST for that interim period you mentioned, and that the BAU might be taken in a different, more expansive framework, or what do you think's happening there?
Yeah, actually, I know of quite a few end clients who were relying on the off-payroll rules being delayed for another year and therefore hadn't prepared in time, which, you know, yeah, arguably that's unforgivable, but we were where we were. And I think, you know, it was a question that, well, we still have COVID, and COVID was the reason why it was delayed in 2020, therefore we might get it again. And therefore there was a real rush to the finish. And the problem is, you know, when they don't have those resources in-house, and, you know, most of the good external parties that do IR35 assessments were very busy. So what choice did they have but to use an automated tool, you know, that was, you know, relatively quick and it's free? Well, you know, great. That's what we'll use just to get over the line for our current contractors. But the vast majority of them, you know, probably partly, I think, as a result of some of my advice, but also, other commentators as well, that will not be their long-term approach. It can't be, because of the massive failings within the CEST tool. It is so unfit for purpose that they may have done enough just to comply with their legal obligations in time for the 6th of April, but they will not, and certainly they should not, use CEST longer term. So then they have a whole program around, so who are we going to use? How are we going to do these status determinations more accurately, more consistently, and how do we make sure that we capture everyone who may be affected? So it's good news that clients are already thinking about changing their position to use a better, more reliable way to determine status. But there's no getting away from the fact that they have exposure in the interim, despite the fact that HMRC says CEST is fit for purpose. It clearly isn't, and we know gives inaccurate outcomes because it doesn't align with case law. So they're putting themselves at risk in the meantime, but at least they are looking to do it better longer term.
So coming back to the subject of this think tank session, is when we're looking at the reasonable care element, you've noted there quite correctly that CEST isn't fit for purpose. Is there any danger of HMRC saying, well, yeah, we put this tool out there, but that still doesn't mean you're meeting reasonable care tests? Do you think there's any danger of that?
Well, we know for a fact that has happened. NHS Digital, who was a public authority who used the CEST tool for a period of 20 months and only 20 months, they were hit with a £4.3 million tax liability because they used CEST. So I think the thing is that there are a lot of people, whether that's clients or agencies, that think, well, if the end client uses the CEST tool, as soon as HMRC sees a bunch of CEST printouts, they'll go, okay, great, you've used CEST, no problem at all, thanks very much, and leave and go on to the next company. But that's just not the case. Even where CEST is used, HMRC will look into the particular arrangements of individual assignments and see whether questions on the CEST tool have been answered in the same way that they would have answered them. And if that's not the case, well, then they won't allow the CEST tool to be relied upon to give an accurate status determination, and you won't have discharged your duty of reasonable care. So, HMRC saying that they will allow, that CEST is, on the face of it, evidence of reasonable care is just nonsense. They're not taking that as a get out of jail free card, and they are going into the individual circumstances, and they are checking whether companies are gaming the tool to answer questions in particular ways to get an outside IR35 status determination. And where you do that, you will be exposed to the kinds of liabilities that NHS Digital were.
And I think it's absolutely inevitable that the CEST tool is being gamed. You can see it's very, very easy to run it through a few times, change one or two questions which to be on the cusp, and get a different outcome.
I was going to say, Rhys, I wonder how many of those 1.2 million are linked to people who have gone through it again to get a different answer. And it's really, and I say that kind of jokingly, but it's really important here because, like Bernie said, it's not enough just to have a CEST determination. The information you put into it has to, of course, be accurate. It has to be reflective of the working practices and not just the contract. And HMRC, an IR35 inquiry works on, we talk to the contractor, we talk to the end client, and we put the answers together. And, oh, hang on a minute, this isn't quite what was put into CEST. So that's out the window. That's gone. And now we start again with constructing the hypothetical contract. And it's going to happen. It's going to happen, and people are going to. It's back to when we've said it before. This isn't about gaming the system and getting around the system. This is a time where HMRC have said, let's put the past behind us, let's move forward, and therefore let's get a genuine status determination and operate compliantly going forward in the future.
Yeah, absolutely. And I think coming back to your point earlier, that if you're taking active steps to game a CEST tool to get the right determination, you're into deliberate you're into deliberate steps there, and those are big penalties, never mind the tax liability. And HMRC has said that it will be lenient in the first 12 months where a genuine mistake has been made. Well, gaming a cess tool is definitely not a genuine mistake. So you can say goodbye to those leniency points.
I dare say if an organisation was doing that on a large scale, the revenue would even be considering fraud.
Yeah, for sure. Okay, good. So that's a very comprehensive way that end clients can start looking, or should be start looking at their IR35 frameworks. Carla, I'd like to come on to you for the agencies. Obviously, agencies hold a key position in the supply chain. What should they be doing at the moment if they haven't taken any steps to put their IR35 plans in place?
Well, if the agencies haven't heard from the clients, they should certainly be making inquiries with the client now and ensure that they are protected legally, because as the fee payer, the ultimate responsibility does sit with them. But of course, we've covered the aspect of reasonable care. So if the client hasn't done the status determination, then of course they could potentially be off the hook. But nevertheless, agencies need to be speaking with clients on a regular basis, assisting them with the SDS if they've got the expertise to do so, and liaising with their contractors on a regular basis so that all parties in the chain know what's going on and everything's transparent.
In that situation where the end client the agency knows that the end client should be doing determinations, but hasn't done anything, and the agency continues to supply entities on a knowing basis that the end client hasn't met their reasonable care requirements, and therefore is the assumed fee payer for the time being. What's to stop agencies from just operating as normal and just continuing that on the basis that, yes, they're the fee payer if the SDS has been passed down, but on the basis the SDS hasn't been passed down, the end client assumes the role as the fee payer and is liable? Do we think that agencies are going to be operating like that and not having those communications with their end clients on the basis they're just saying, well, it's not our job initially?
That sounds like very risky territory to me, and I guess this would also depend upon what's really sitting in their contracts. I would have thought they'd certainly want to be having a conversation with the client to encourage them to fulfill their obligations, because doing nothing, we all know that sticking your head in the sand is never likely to lead to a good outcome. So I think as always, it's get the conversation started and start getting compliant.
So I actually have a slightly different viewpoint, if you don't mind. So one of the things that I always say to my agency clients is, you either want your client to have done SDSs and to have used a suitable, appropriate way of assessing that is most likely to result in accurate outcomes, or you want them to have done nothing. Because actually it's in that middle point that agencies are most exposed. So what I mean by that is, if the client hasn't done SDSs, then as you quite rightly said, Reece, the client is the fee payer. So then, agencies are off the hook. Similarly, if the client has done really good assessments and all of the outcomes of their SDSs are correct in law, under the case law that determines IR35 status, then the agency is also in a good position because it follows the client's SDS and those are the right outcomes. It's the bit in the middle where agencies are most exposed because of the client having a variable obligation of reasonable care, but fee payers, the agencies, having an absolute obligation to deduct the right tax and NIGs. If a client does a status assessment and they can prove reasonable care, but HMRC believes the outcome of the assessment was just wrong, that liability sits with the agency despite the fact that they've done nothing wrong. It's called the fee payer risk, and potentially it's a very considerable one. So actually I would say yes, you do want to put, agencies should be pushing clients to get a move on and do status determinations if they don't have them. But I think there are circumstances for the agencies to sit back and do nothing and just carry on supplying PSCs because they aren't liable. The only time I would say, or the occasions in which you would not want to do that, are if there is an indemnity in the client's terms and conditions with the agency that says if there is a tax liability, even if it's arisen due to the fault of the client, that the agency will be liable. Obviously, under those circumstances, you take the risk averse approach because you will be liable under contract, even though the client is liable under law. And the other circumstance really would be perhaps where that is a very close client of yours, particularly if you are a sole supplier to that client and they are a very important client. And if you are doing nothing, then the reputational outcome, once the client does realise that you've continued to supply PSCs to them, knowing that they hold the liability, could potentially put you in a difficult position from a commercial and reputational perspective.
Absolutely right. I think those are the 2 points that kind of fit neatly into both Chris and Bernie's perspectives there, is that the commercial risk associated with doing that is huge, because your end client is expecting you to be putting in the correct hiring processes, doing the background checks, making sure the contracts are done, doing everything right. So IR35 for me is just another step in that chain, that the end client is looking for the agency to earn their percentage by making sure that the correct hiring process is met. And whilst we may say that the end client is responsible for that, they are, that's just the fact of the legislation. I think end clients would be thinking that the agency should be informing them what to do and taking a key role in that. So I completely agree with you. And also coming back to the point earlier with the contractual terms, where we see waterfall provisions flowing down the supply chain into indemnity provisions and tax loss provisions, agencies may well be on the hook regardless. So lots to think about there if agencies are considering taking that position. But Bernie, equally, you're exactly right. I mean, that middle ground of limbo is where agencies would be most uncomfortable. And I would have thought that if an agency sees their end clients giving CEF determinations and passing that down, those agencies should be saying, well, hold on, we need to take a closer look at this, because the agency is the liable party as the fee payer. But it's questionable over whether the SDS is going to be correct, given that it's been done by CEF. So a key importance for the agencies to take control of that chain there. Chris?
It's just worth pointing out that the deemed employer, the fee payer in this scenario, does have the ability to start the client-led status disagreement process like the worker. So if they find themselves in a situation where they don't agree with the status determination statement, there is a prescribed process that they can follow, whereupon they can lodge their disagreement, and the client has 45 days to respond. So there is a mechanism for them to challenge that decision, and they should use it if they're not happy with the decision that's been passed down.
Excellent. Well, that's a fantastic segue for me, where I was going to come to you and ask you, given we've looked at agencies and end clients, what should contractors be doing? Obviously, a lot of the risk has been removed, but for provisions through the contract. But the most obvious one of that, following the 6th of April, is the legislative support for a disagreement process now. So what should contractors be looking to do?
Well, from a contractor's point of view, I guess, well, first of all, hopefully they've been engaged in the process from the beginning, and that there has been good positive dialogue either with the agency or with the client themselves over the assessment process. And they, I think all good assessment processes will expect to involve the worker at some stage during the decision-making process, because after all, they represent 50% of the parties involved in terms of providing services. So hopefully all the right things have been done in that sense. That's the key thing to think about here. Thereafter, I think it's just a question of just making sure that everything reflects the working practices, and that in situations where they're seeing assessments coming through to them providing reasons that they don't agree with, then yes, they should absolutely use the client-led status disagreement process to challenge that position. And if they do that, they need to be mindful that they can't just say, I don't agree with it. They have to give positive reasons as to why they're challenging that assessment. And then, as I say, the client has got a 45-day period in which to respond to either uphold the decision that was originally issued, or indeed to provide a correction. And when providing a correction, that would involve issuing a new status determination statement with an effective date as to when that decision took effect. So for that, it could be from the very beginning of the assignment, or it could be taken from a certain point in time, because I think, as Bernie mentioned earlier, assignments can and do change mid-assignment, where you have sort of mission creep going on, and there's every possibility that that process could be initiated mid-assignment.
Absolutely. Bernie, please. Yep.
So one of the other things that I think we've seen quite a lot in the market, that's specifically from the contractor perspective, is a lot of contractors being asked to pay for their own IR35 assessments. So instead of the client, paying for their, external advice or external assessor, they're utilising an external assessor, and individual contractors have to pay for that. And that's usually anywhere between £100 and £200 for the assessment. And then they have to pay for subsequent reassessments every sort of 3, 6, 9, 12, whatever months. And then they are required, if they are outside IR35, to purchase their own IR35 insurance that covers both the fee payer and the client as well. So, and for a lot of contractors, they will accept the cost of the assessments, both upfront and ongoing. And if outside IR35, they will, accept the costs of the insurance. But I think the difficulty is that that's obviously commercially you can agree anything, but that's not really what the legislation intended. I think, the idea is, if a client has a legal obligation to understand a specific area of law, yes, they can use external advisors, but surely the client should be paying for that advice rather than individual contractors. And then, with regards to the insurances, of course, PSCs have to hold their own insurances anyway. But when we're talking specifically about IR35 insurance, yes, a contractor can purchase it, but that doesn't mean the contractor will maintain it for the next 6 years. And if it's a claims made insurance policy, then of course, as soon as they don't renew it, then the insurance policy is no longer valid for any retrospective claims. And also, of course, even though the fee payer and the client are additional insureds, the PSC is the policyholder. And if the PSC refuses to claim on that insurance, it's not available to anyone. So I think there's a lot of money being spent, particularly by contractors, which actually potentially neither them nor the fee payer nor the client will actually get a benefit of. So I do think there's been, it's not always done cynically, but I do think there has been, quite a lot of impact on contractors in that sense.
It's amazing, really, isn't it? Amazing that, the considerations around that. I think, it's an important point. In terms of just going back to that disagreement process, we've often talked around blanket assessments and blanket determinations. Obviously, we know blanket determinations are not supportive of the reasonable care requirements. Is there a way of utilizing the disagreement process now that it's in place to try and buck the trend on blanket positions with HMRC, with the end client. So if the end client says it's all IR35, everyone's inside IR35, and you use that disagreement process, let's assume for the sake of the question that the end hirer has 1,000 contractors and has applied a blanket determination to the role on the basis of an administrative burden of having to individually assess that. Obviously, we know there's problems there that we've already discussed, but the disagreement process really forces that end client to look at the position on a individual basis and reconfirm the reasons why they've given those determinations. Coming to both Chris and Bernie's point there is that the contractors are getting the IR35 assessments done independently. Presumably that independent IR35 assessment is going to be very helpful in the disagreement process by saying, well, I've got this done by an independent third-party law firm, and they think I'm outside, so why are you putting me inside? And they have to then look at that within the next 40 days and give a reconfirmed or a revised determination that will have to take into consideration that third-party review. So that presumably will be helpful in terms of that process. But do we think that disagreement process can be used to force a change almost, where it may not otherwise be the case?
Yes, so a couple of agency clients that I know of have end clients who did blanket assessments, so decided that everyone was inside IR35. They did issue SDSs, but every single SDS for every single role was exactly the same. So it didn't even have a role or anything on it. It just said all PSCs pretty much. And what those agencies did, along with the individual workers as well, was that they issued status determinations, yes, based on specific evidence with regards to their assignment, but they also put in writing in their challenge, we believe that this client has undertaken a blanket assessment determining everyone inside IR35. So the client then gets 20, 30, 100, 400 challenges in from various parties in the supply chain, all of which are saying, we believe the client has taken a blanket approach and determined everyone inside IR35. Now, the reason for doing that is, we know from the HMRC guidance that where a client has taken a blanket approach and simply determined everyone inside IR35, then they will be liable for all of the unpaid taxes and NICs, even if it's been paid somewhere else in the chain. There is an additional disincentive for clients to do that by virtue of the fact that, yes, fee payers still need to deduct the tax and NICs, but the client will be basically charged the same amount again by virtue of the fact that they are cynically misusing the legislation to deem everyone inside IR35. So what happens is, as soon as HMRC comes along to look at any particular fee payer, if it's for that client, the agency can say, well, we know of 20, 40 challenges that went to the client that clearly say that we believe they took a blanket approach. I think you need to go and talk to that client about whether they actually did assess on an individual or role basis. And that puts the client in a very, very difficult and uncomfortable position once it comes to the time that HMRC begins to enforce this.
So then we expect a reconfirmed a revised state determination statement and a change to the effective date, as Chris says, placing it back to the start of the contract. I mean, it has to be the way, for me, it has to be the way that contractors can take back some ownership over the process. Clearly, contractors have lost all sorts of autonomy in the chain from all other areas, whilst taking on greater costs with the IR35 review, as you say, Bernie, potentially being forced inside IR35, so having a lower take home. So that for me is where contractors really need to be focusing in terms of trying to gain back some control over their supply chain if they've been forced inside, looking at that disagreement process, looking at how the end hirer has made the status determination, and then perhaps getting an independent third-party review conducted just to assess the situation. And all of these aren't necessarily points of each supply chain entity trying to get one up on the other supply chain. The whole point of what we're trying to say is that the transparency in the supply chain needs to be there. I think Chris said it, hopefully everyone's been speaking to everyone in the supply chain the whole time. There shouldn't really be any reason for these late stage disagreements. Everyone should be communicating everything all the way along. This is how we've had it checked. This is the determinations we've made. This is where we've got to. This is the determination for this reason. And that's where we are. Unfortunately, in a lot of cases, that hasn't been the case because IR35 has been put to the side to kind of progress other matters. But we do need to force that focus back into the supply chain opening up and everyone speaking to everyone. And I think agencies will take a key point in that and be linking everyone up. As we said earlier, they'll be wanting to speak to their own clients. They should be communicating status determinations to their contractors in an open and transparent way to ensure these disagreement processes don't create unnecessary burden for the end client and unnecessary commercial risk for everyone else. So there's a lot to be said for just talking to everyone in the supply chain, getting everyone on the same page, I think, because as soon as you start invoking these disagreement processes or agencies start standing back and allowing their own clients to not make status determinations, you're at risk. The contractual obligations may be at risk, the legislation may be at risk, and it's certainly the case that you're not taking the right steps, so the leniency might not apply. So lots to think about there for the whole supply chain, I think, and lots of steps to take. Good, okay, well, does anyone have anything further they'd like to add to the topic? Bernie? Anton, Bernie first.
Just the kind of final thought from me is, yes, we may have leniency under the IR35 rules. And as Tom has clearly pointed out, that leniency is very limited and specific. But we may have that leniency for the first 12 months. But I think what all people in the supply chain need to remember and understand is that, particularly if and where contractors have been deemed inside IR35 and have moved to a different payroll mechanism, so such as a umbrella, for example, or even potentially some kind of sole trader model, well, there is no leniency under those types of legislation that govern those types of arrangements. So particularly things like the onshore offshore intermediaries legislation, for example. So you may have some leniency under IR35, but there is no leniency for established legislation relating to the collection of tax and NICs when you work with umbrella companies or CIS intermediaries or any of those types. That legislation has been enforced for a number of years, and there is, there's no way out of that. So I think, it's just that's important to remember is that a lot of contractors are still PSCs because they have been deemed outside IR35, but for those deemed inside IR35, you must ensure that the mechanism, the payroll model that you engage those contractors on is compliant, because there's no leniency there.
Yeah, I mean, like Bernie, I was going to talk about the narrowness of the leniency, and I know I'm still talking to people, I know Labour's still talking to, and Carla's still talking to people who are saying, well, I'm working for an end client who is subject to the small companies exemption, therefore I'm not subject to IR35. Okay, the reforms you're not subject to, but you're subject to IR35 like you have been for the last 21 years now. So do not expect leniency when HMRC knock at the door and you say, well, I've got 12 months to get this right. No, you've had 21 years to get this right. You just simply can't rely on that, and you need to be doing assessments just the same as an end client needs to be doing an assessment, not putting your finger in the air and assuming that you're outside IR35 just because you've never been challenged. You might be challenged and you might find you're inside, and you might find you have a lot of tax and penalties to pay as a result of that.
Yeah, absolutely. And I think we talk on these sessions a lot about ongoing compliance and ongoing reviews of situations, and IR35 in particular, but that also involves ongoing reviews of the end client's position under the small companies exemption as well. If a company ticks over into 51 employees, they need to be looking at the situation again. And it's certainly the case that we monitor our own clients and make sure that those provisions are met. But agencies need to be doing that as well and thinking about that. But most importantly, end clients need to be thinking about that. Yes, they may meet the small companies exemption now, but that may not be the case in the future. Chris, I think you wanted to add something as well.
Well, I was just going to say, in this situation, I guess a lot of people should be assuming that that an inquiry might be inevitable at some point down the chain, and the same as with all other statutory taxes and so forth. That keeping good records is absolutely key to this, making sure that that the evidence that's led to the status determination statement being issued is recorded and kept, and that's certainly what we're doing within IR35 Navigator, in that we're using that as an environment to gather the evidence and store it alongside the decision, as well as recording it on blockchain, which I know we covered in a previous session, so that there is sort of immutable evidence there to support an inquiry should it happen in the future.
Yeah, absolutely. I mean, Tom, I don't know whether you have any thoughts on how quickly HMRC are going to spin up into IR35 investigations. I would have thought pretty much immediately.
Well, they've been sitting on their hands for 12 months itching to get at it. I mean, they expected to be spinning up this time last year. Certainly we're given the resources to do it for this time last year. Look, the process clearly has to bed in. So I don't expect anything for a couple of months, but I don't expect HMRC to let sort of, 12 months pass. I think they'll very quickly be looking at initially looking at some of the bigger end clients. We know some time ago they sort of sent some letters to some pharma companies sort of talking about their contractors. Perhaps we'll get that kind of approach again to say, look, you had a large contractor base, you still have a large contractor base, what gives? But from there, I think we'll start to rapidly see inquiries into PSCs and really the nitty gritty kind of tax investigation work that we've, I think, to be fair, seen ramping up in the last couple of years. I think we've already seen that.
Yeah.
We'll continue to see that ramping up.
Yeah, I agree. Good. Would anyone else like to add any final thoughts, remarks?
I just wanted to make a final comment about assessment tools. We talked about how flawed the CES tool is, and I think everybody accepts that. However, the algorithms that are out there can also be gamed, and it's easy to manipulate those answers on the algorithm-based tools. Basically, at the end of the day, nothing beats looking at a contract, having it looked at manually. I mean, from our perspective, we speak to every contractor because quite often they don't understand the questions that are being posed. And therefore, the answers that are submitted are quite often wrong. So the manual process is definitely the best approach from a reasonable care perspective.
Yeah, absolutely. Absolutely. You can't beat a lawyer looking at the documents, can you? Good. All right. Well, thank you all very much for your time as usual. Another fantastic session, which we'll upload a recording of. If anyone wants to speak to any of our panel members, feel free to get in contact at hello@ir35navigator.com. And until next Thursday, we'll see you all again.